Why Article 32 hearings are still a strategic goldmine for the defense. Most service members hear Article 32 and they assume the worst. The prosecutors are ready, the case is going to trial, and the government is just pencil whipping your rights. If you believe that, you've already lost. Look, an Article 32 is not just paperwork. It is the first formal, and sometimes it's the best chance to kill a case before it becomes a court-martial. Some lawyers will tell you, I always waive the 32. Others might say, I never waive. Let me be clear, both are wrong. The only correct answer is strategic. Look, if you or someone you love is facing military allegations, you need to understand why this stage, the Article 32 preliminary hearing, is high ground for your defense. Article 32 hearings are fact-specific. There is no default setting. If an attorney says, this is just how I do it, that's not a plan, that's a habit. And in the military justice system, habits get people crushed. It's true, the system has changed. It used to be called an Article 32 investigation, and it was much broader, and there were a lot more opportunities for the defense. And now it's more narrow and it's more limited than it used to be. Some of the old lawyers looked at the new rules and just gave up on Article 32s, claiming the hearing only helps the government now. And they're partially right. If you're sloppy, you can tip your hand to the prosecution. But sometimes doesn't mean always. Even under the current rules, the Article 32 is still a battlefield where we can expose weak evidence and force the government to commit to a failing theory. The first mistake is thinking a decision is binary, yes or no. But these decisions are bigger than that. They're deeper than that. The question is, when is waiving a 32 strategic? When the government has a flaw, maybe it's a massive flaw in their case and they haven't found it yet, and we want to keep them blind. Maybe it's that the defense knows there's evidence in the fourth pillar that would be amazing, but we want to keep it as a surprise at this time. When timing is everything, speeding up the process to get a client out of pretrial confinement or toward a resignation, or when the alternative to court-martial is administrative separation, and we don't want a foe not to recommend court-martial because then the person gets kicked out. All right, so when is fighting strategic? When the alleged victim's story is physically impossible, when the charges don't actually match the facts provided in the CID or the OSI reports, when you need to create a record of weakness that forces the preliminary hearing officer to recommend against trial. Those are all possibilities for a strategic non-waiver. Here's the hard truth. What's good for a lawyer's resume isn't always best for the client. When I was active duty, I remember a particular case that we were getting ready to argue at the Article 32 preliminary hearing. And I talked to my senior lawyer, and she talked to other senior lawyers, and they all recommended, don't do it. Don't fight at the 32, save it for trial. Here's the problem. A big win at a general court-martial looks great on a performance report, but clients don't need dramatic trial victories. If you can take that same case and get it dismissed at the Article 32, that's better for the client. And our goal as lawyers should be not to create some sort of highlight reel, perfect records in the courtroom so that you can sell more cases. Our goal is supposed to be damage control for our clients. Now, if we can expose a witness's lack of credibility now, at this point in time, we might avoid months of public exposure for the client, months of family stress, and the risk of a felony conviction. A strong defense doesn't just wait for trial because it's more exciting or it gets that lawyer more recognition. Here's the deal. People underestimate these hearings because the law has changed and the standard is so low. It's probable cause. I hear people underestimate these hearings all the time because they say, look, this is just a probable cause hearing. And probable cause, it's a low bar. Just enough evidence to suggest a crime might have happened by this person. But the hearing isn't just about if a crime happened. It's about how and what should happen based on the evidence that the government has. Look, the foe is not just saying whether there's probable cause or not. One of the four decisions for determination for that foe is recommendation as to disposition. This is the real target for the defense. We are not just arguing the client didn't do it. We are arguing that the evidence is so thin that it cannot obtain and sustain a conviction at trial using the beyond a reasonable doubt standard. Look, if we can convince a foe that a trial would be a waste of the Navy's time or the Army's time or the Air Force's time and resources, the case starts to move the direction we want. So there are 4 ways that I have to handle the hearing itself. And it really depends on each case what you're going to do. The first is the heavy hitter strategy. This is where we litigate hard. We attack the elements. We put the government's weaknesses on record as early as possible so that the foe cannot ignore them. This is for when the case is a house of cards just ready to fall. All right, the second one is what I call the bump on a log strategy. We say nothing. We let the government present their case without showing a single card from our hand. To the outsider, it might look like it's a passive lawyer doing nothing. But to a strategic lawyer, sometimes it's a trap. Sometimes we're protecting the silver bullets we already know about for the day that they matter most. The third strategy is more advanced. The third strategy is a wait and see approach. This is one where we prepare for war, but we start the hearing in silence. We watch the foe, and if the foe starts asking the prosecutor questions like, where is the forensic support for this? Where is the evidence for that? That's our cue. That's when we step in to reinforce the preliminary hearing officer's own doubts. Let me give you an example. I was on a case, and it was a team defense with a civilian defense counsel, and it was when I was still active duty, and I was the IMDC. This was a multiple victim Article 120 offense. And we did the wait and see approach. All right, so what we did, we were prepared to argue, but we were going to sit on our hands. We get into the hearing, and this is handled by an OSTC prosecutor. And as we get going, it's clear. The preliminary hearing officer, who happened to be a military judge, started asking good questions. And that's when our strategy shifted from sitting on our hands to making the arguments clear that the judge was right. And the preliminary hearing officer, when he wrote his report, recommended dismissal of the charges. That's the wait and see approach. The fourth strategy is what I call the reality check. Now, the reality check might be for the prosecutor, it might be for the alleged victim, or the victim's counsel in the case. So what do I mean? When the reality check is not arguing to the preliminary hearing officer. Your goal is not to win an argument in front of the preliminary hearing officer. Your goal is to put on a show so the people in the room know what's coming. All right, so what do I mean? Sometimes you might have an alleged victim in the room, or maybe their victim's counsel in the room. And the argument and the evidence that you're presenting isn't about convincing the preliminary hearing officer. It's about them seeing what trial will actually look like. It's also for the prosecutor. Maybe they think they have a slam dunk, and you want to make sure that they understand from the get-go that that is not the case. And when they see the defense armed with text messages, timelines, impeachment evidence, character evidence about the untruthfulness of the alleged victim, sometimes it's the alleged victim, and sometimes it's the prosecution that suddenly becomes much more open to an administrative resolution. And if that's what you're going for, the Article 32 preliminary hearing can be a great tool to get you there. Okay, well, now in the current status of the UCMJ, we have these special trial counsels. Some services call it OSTC, sometimes call it OSTIC, but when the STC gets involved, some service members panic. They think, oh, these are the specialized varsity team prosecutors, so the case is a done deal. I've even heard STCs from multiple services saying, we will not take a case to an Article 32 that we don't intend to prosecute. Okay, well, that's a good idea, and I like the approach to that, but in reality, that's not the case. I've sat in on cases with special trial counsel where I've served as a legal advisor in my reserve capacity that went to an Article 32 preliminary hearing. The recommendation was dismissal, and lo and behold, OSTC immediately dismissed the case after receiving the preliminary hearing report. I've also seen it where an STC is on the case, where they say they're going forward, and then the Article 32 shows what's going to happen, and OSTC opens their eyes and recognizes there's something more to do. Look, a prosecutor can be highly specialized and still also have a witness who is lying. Specialization and confidence of the prosecutor is not the same as good evidence. Do not let the title of the person across the courtroom from you scare you into waiving your best opportunity to fight, if fighting at that Article 32 is strategically in your best interest. Before you walk into a preliminary hearing, your team needs to master these 4 pillars. These are the 4 pillars of a good defense. What they think, that's the story the government is telling. What we know, this is the context they are missing, the why behind the what, or the facts that they just haven't found yet. The evidence that they have, what do they actually have in the case file? Not what they claim, but what is signed and sworn and solid evidence. And the 4th pillar is evidence we can get. What evidence do we know about that exists in this world that the prosecution hasn't yet found? What is hidden that we can uncover? Or what is hidden that we need to keep hidden? Those 4 pillars need to be discussed early and often throughout your strategy. Okay, so here's some red flags. If you're talking to a lawyer about an Article 32, doesn't matter if it's a detailed military lawyer or you're talking to a civilian defense counsel that might be coming on to your case, you need to watch for these 5 red flags. The first, the automatic answer. I always waive these hearings. Look, this is laziness. This is not a good practice of law. Second, the blind advice. They tell you to waive before they've even finished reading the report. That's also a bad idea. The third one, I call this the ignored client. They haven't asked for your side of the story yet. It is shocking to hear how many defense attorneys are out there, and good defense attorneys with experience that haven't asked their client what truly happened until the eve of trial. No, you should know this before the Article 32 so that you can make the best advice for your clients. All right, the next one is the trial-only focus. This is the people who love trial and they only dream about getting into the courtroom and winning acquittals in the courtroom. Those are the people who ignore chances throughout the process to end it now. The last one is called the procedural attitude. This is where they treat your career and your freedom like a formality. This is the people that are saying, nope, this is just a box to check. We're not gonna look at going. We're not gonna look at what we can do with it. We're not gonna strategize. This is just a step along the process. All right, here's the deal. The Article 32 preliminary hearing won't save every case. It is not magic. But in the hands of a legal strategist, in the hands of somebody who knows what they're doing, this Article 32 preliminary hearing can be a gold mine. This is the moment where we test the government's armor. If there's a crack, we find it then. If there's a leak, we exploit it. Or we choose not to strategically. But don't let your lawyer treat this like just another box to check, something to pencil whip. Treat it like the crossroads it is. When you're dealing with your lawyer about Article 32, whether there's advice to waive it or not waive it, you need to ask the hard questions. What is our specific goal for this hearing? What are we willing to reveal to the government if we have things to reveal? How does this end the case today? Is it possible that our arguments can end the case today? Or is it possible that our arguments can help us get the case ended before trial? Those are the questions you need to be asked. Because in military justice, the best victory isn't the one that happens at trial months later. It's the one that ensures that trial never happens at all. I love the courtroom. I love going into the courtroom. I love getting full acquittals at trial. But for most of our clients, that is not the right place to be. For most of our clients, finding a resolution before making it all the way to trial is the best place for them. And a strategy that recognizes that and considers that is what you're looking for.